seated. Good morning. Welcome to the First District Court of Appeal. We have one case on the docket today. It is Proffitt v. State, case number 213588. Counsel for the appellant, you may proceed when you're ready.
Thank you, Judge Ray. May it please the court. Mose Bracey on behalf of Mr. Proffitt. I'd like to reserve 3 minutes for rebuttal, please.
So noted.
I hope to focus on issue 2, which deals with Mr. Proffitt's lawyer's failure to file a motion for arrest of judgment as to the jury's general verdict finding Mr. Proffitt guilty of first-degree murder. And I hope to do so at least initially by stating what I believe to be the crux of the issue and then elaborating on the reasons why I believe this court should reverse and remand for a new trial. This is the rare case where a district court of appeal decision as to which there was no interdistrict conflict was directly on point. It's also the rare case where, without any conceivable technical purpose, the trial attorney failed to bring that decision to the trial court's attention. And finally, where, despite the fact that the law in that area had long been on the books, the trial judge failed to at least speak up and state, as trial courts often do, something along the lines of, we don't want this case coming back on appeal. Is there maybe anything we need to look at with the verdict? And so I hope to make 4 main points today in support of issue 2. 1, Mr. Proffitt's lawyer's failure constituted ineffective assistance of counsel on the face of the record. 2, it also amounted to fundamental error. 3, TEB versus State and Patland versus State, which are 2 post the Florida Supreme Court's decision in Steiger versus State. Those 2 decisions should persuade this court to conclude that reversible error occurred. And then finally, this court's decision in Ford v. State should not prevent such a conclusion.
Are issues or the questions you've presented in 1 and 2 essentially the same? In other words, in order to find on direct appeal ineffective assistance of counsel on the face of the record, there must be fundamental error. So we need to address the fundamental error question. It's a threshold matter. Is that correct?
Well, Judge Ray, I certainly think that in connection with either issue, certainly in connection with issue 2, fundamental error would be an issue. Fundamental error could also be an issue in issue 1 as well. That said, and I acknowledge that there is some overlap between the issues. However, I think it's important to recognize that, for instance, whereas in connection with issue 1, this court could certainly say we disagree with the Second Circuit's, the Second District's decision in Shavers, or we agree with it on the merits, but find the error here to be harmless. That's not the case for the trial judge as far as what the trial court could have done in connection with issue 2. I believe that where issue 2 is concerned, the trial judge would have been bound to follow Shavers in the absence of any
But
different
isn't Shavers distinguishable in several material respects? I mean, in that case, if I recall correctly, the jury did not find that a gun was possessed and discharged, and the issue was preserved, unlike in this case.
Yes, ma'am. Well, certainly the issue there was preserved by, I believe it was a motion for new trial. Whereas here, the argument in connection with issue 1 would be that it was either preserved by B2 or fundamental. I don't think that would factor into the merits analysis as far as whether Shavers on the merits was on point with this case. And then the jury finding really in Shavers, if you look closely, that really comes into play in the harmless error analysis, which I acknowledge that a harmless error analysis here, there would be some different facts here versus there, and vice versa. I still believe that on issue 1, the error here would not be harmless, but I acknowledge that there are some differences in terms of the harmless error analysis, but on the merits, in terms of the procedural facts, because of course the historical underlying facts, I mean, those are different to some degree in the 2 cases, but the procedural facts in terms of this is what the charges were, this is what the jury was instructed, this is the verdict that returned. I mean, I think those facts are virtually indistinguishable, between Shavers and between the facts that we have here. So I do believe, again, on the merits, that Shavers is directly on point. Now, again, this court could disagree with Shavers. This court could find the error to be harmless, but I don't think the trial judge would have had the same discretion. And that kind of leads me to circle back to sort of the first main point, that that it was ineffective assistance of counsel on the face of the record. And I would just start there by saying Mr. Proffitt had not just the right to a lawyer, but the right to reasonably adequate legal assistance under prevailing professional norms. And of course, his lawyer was required to, he had a duty to advocate Mr. Proffitt's cause. And here, the failure to file the motion for arrest of judgment was patently unreasonable. There was no conceivable tactical purpose for not bringing at least Shavers to the trial court's attention. And I say that for a few reasons. One, not being aware of Shavers and the other relevant law would have been patently unreasonable. It had been on the books. Shavers, a 2012 case. Of course, that area of the law has been developing for decades. So it would have been patently unreasonable to not be aware of it. Furthermore, to have been aware of that case law, but to not have used it to advocate Mr. Proffitt's cause would also have been patently unreasonable. There would have been no conceivable tactical purpose. And I say that for two main reasons. One, there would have been really no downside to filing a motion for arrest of judgment prior to sentencing. I mean, at that point, the only thing really left for the court to do is to impose a mandatory life without parole sentence and to adjudicate Mr. Proffitt guilty of first-degree murder. On the flip side, I believe that the upside of filing such a motion was really undeniable. Again, at least on the merits, Shavers was directly on point in my view, and as we all know under the Pardo Doctrine, you know, a decision by one Florida district court is binding on all trial
Counsel,
courts.
if we disagree that Shavers was directly on all fours and the trial court was therefore not bound by it, can you go into the fundamental error analysis, why you think fundamental error occurred here?
Sure. In connection with issue 2 or issue 1, Judge? I mean, because I do think
Well,
there's
I think,
slightly.
okay, I'm sorry. If you think there's a distinction, please flesh that out.
Yes, ma'am. Yes, ma'am. Well, in connection with issue 2, I believe fundamental error occurred for two main reasons. One, because I don't think that the result here, you know, the imposition of a life in prison sentence and the adjudication of guilt for first-degree murder, I don't believe that could have been obtained without the trial judge's failure to file the motion for arrest of judgment. In addition, I think that that failure was basically vitiated the basic validity of the trial and the trial proceedings. And so if I could kind of unpack both of those, again, in terms of the result not being able to have been obtained in the absence of the failure, basically for the trial judge to sentence Mr. Proffitt, you know, to life in prison and adjudicate him guilty, the judge had to, you know, first enter judgment, or in the process enter judgment on the jury's general verdict. And again, my view is that if the lawyer would have filed the motion for arrest of judgment, the trial court would have been bound to grant it. Even if for some reason the trial court took the view that Shavers wasn't directly on point, I certainly think that Fitzpatrick, while perhaps not as directly on point, was on point. But the bottom line is I think the judge would have been bound to grant the motion and therefore not been able to enter judgment. So I don't think that result could have been obtained without the trial court's failure. I also believe it vitiated the basic validity of the trial, and I say that for three reasons. One, I think it was equivalent to a denial of due process. Two, I think prejudice followed that failure. And three, I believe that the interest of that correcting the error would further the interest of justice. And in terms of it being equivalent to a denial of due process, I would just focus on the fact that in cases such as Cronic versus United States, Strickland versus Washington, the U.S. Supreme Court has said things like, you know, the right to a lawyer is the most pervasive of all rights. A defendant's ability to assert all their other rights depend on their right to a lawyer, the right to effective assistance. You know, the court's also made clear that a lawyer has a duty to advocate their client's cause, an overarching duty.
Well, would you agree that for there to be ineffective assistance and fundamental error, there had to have first been a true and consistent verdict, right?
Yes, sir, or a verdict
Okay.
that could have been based on a
Okay,
legally.
let me follow up on that then.
Sure.
The felony murder instruction to the jury said they could find felony murder based on robbery or attempted robbery. The verdict form, though, didn't include attempted robbery as a lesser of robbery, only petty theft, right? And the jury found petty theft. But how do we know that the jury, in convicting him of murder, just in a general verdict, didn't find he committed the murder in the course of, or the murder was committed in the course of, an attempted robbery?
Well, Judge Bilbrey, I will say with that issue having not come up in the briefs, I have not thought it through as much as I would like. Frankly, I have not thought it through at all. But I would say that because the jury came back with the verdict of petty theft, you know, my view would be that it's more likely they found that it wasn't robbery or attempted robbery. I guess the other thing I would say is that the standard here, the general legal standard, I believe, is actually fairly friendly to Mr. Proffitt in the sense that, you know, the question here really is could the verdict have been based on a legally inadequate theory? And let's assume that deciding that the killing occurred during the commission of an attempted robbery would be legally adequate. I would still argue that the verdict here could have been based on a legally inadequate theory, which would have been that the killing occurred during the commission of a theft. And I say that because three main portions of the jury verdict, and then one thing the jury instructions, three things the jury instructions say, and then one thing the jury's instructions doesn't say, lead me to believe that the jury could have justifiably believed that as a matter of law, though of course contrary to the actual law, a person could be guilty of first-degree felony murder if the killing occurs during the commission of a theft. And those three portions are that the first thing is, and standing alone, this is not a problem, but as you point out, I think, Judge Bilbrey, or certainly recognize, the instructions said that to prove first-degree felony murder, the state must prove that while engaged in the commission of a robbery or attempted robbery, Mr. Proffitt caused the death of Mr. Maldau. Again, standing alone, that's not a problem. But later, the jury instructions say, in considering the evidence, you should consider that although the evidence may not convince you the defendant committed robbery, the evidence may indicate that he committed acts that constitute a lesser included crime. And then shortly thereafter, it says the lesser crime included within the definition of robbery is theft. And at no point in the verdict in the instructions does it say, you know, a defendant cannot be convicted of first-degree felony murder if the killing occurs during the commission of a theft. And so I would say that, you know, there's not only, I guess, I'm at least going to assume for purposes of the argument, Judge, that there's a possibility that the jury could have followed a legally adequate theory of attempted robbery. They also, as the state points out, could have followed a legally and factually adequate theory, at least again, I will assume for the purpose of the argument of premeditated murder. But I would still return to the fact that here the standard is, could the verdict have been based on a legally inadequate theory of conviction, which basically means even if it's possible that the verdict could have been based on a legally or factually adequate theory, if it also could have been based on a legally inadequate theory, then we've got a problem. And I think that's what we have here, Judge Bilbrey. If there are no further questions right now, I'll reserve the balance of my time for rebuttal.
Thank you.
May it please the court, my name is Adam Wilson on behalf of the state, and we're asking that you affirm the defendant's judgment and sentence here. I would like to start actually with the harmless error argument because I think that's the simplest way to dispose of this case. The defendant is alleging that there was a Yates error in this case. A Yates error occurs when there's a general verdict. One of the theories underlying that general verdict is legally inadequate, and it's impossible to tell which theory the jury used in reaching the verdict. Here, I don't think it is impossible to tell based on the interrogatories we have, specifically the interrogatory the defendant discharged the firearm causing the death of the victim. That interrogatory is consistent with premeditated murder and not the felony murder theory. And because we can tell what theory the jury used, this error is harmless. And even if the trial court was bound by Shavers, like Mr. Bracey says, Shavers just says basically that a truly inconsistent verdict is a legally inadequate theory, and then you do a harmless error analysis. So if the trial court was bound by Shavers, it would still have to do its own harmless error analysis. And here, I think the harmless error analysis is clear that this error is harmless.
Counsel, flesh out the distinction between the harmless error analysis and a fundamental error analysis. In the Shavers case, I believe they found the issue was preserved, so they did a harmless error analysis. Here, the state's contention is, and I think it's correct, that the issue was not preserved, so it's a fundamental error analysis. Is that a distinction without a difference, or do you think that's important?
I think it is important in this case because I think if the defendant has to show fundamental error, it's going to be very difficult in this case because a fundamental error reaches down into the validity of the trial such that the verdict could not have occurred. And here with this type of error, we're kind of speculating that perhaps the jury in this case relied on a theory, perhaps because I think we all agree that the premeditation theory is factually and legally adequate. There was sufficient evidence for that. But so we're just speculating that perhaps there's a chance the jury relied on a legally inadequate theory, which, and of course, I don't believe there is any legally inadequate theory in this case, but this speculation I don't think can be fundamental error. But I think you don't even have to decide you don't even have to get into the issue of whether it's preserved, because even if it is preserved, it's still harmless. And turning to the merits of this issue, I think it's important to draw the distinction here between a true inconsistent verdict and a legally inadequate theory. A true inconsistent verdict occurs when the charges are interlocking. I think Judge Bilbrey made a good point that because there is an attempted robbery theory, this may not actually be a true inconsistent verdict. But just the fact that it is truly inconsistent does not necessarily mean that it's an legally inadequate theory.
Are you contending that you've got to request, or somebody's got to request, the trial judge has got to give the legally interlocking counts, standard jury instruction, the 3.12D, for somebody to be able to argue a true inconsistent verdict?
I think yes. Well, yes. If the trial, specific to this case at least, the failure to ask for that jury instruction, given the circumstances of this case, was invited error, and you cannot bring that claim on appeal. And I think that's important because basically appellant sought to have the jury consider each count independently, and that's what he got. We have two specific jury instructions. We have the independent jury instruction, which is the one that was used in this case, and we have the interlocking count one, which is, I think, more appropriate in a case where there's a felony murder and an underlying felony. And I think this court's decision in Knight is particularly instructive, where they found that a jury instruction error was waived because of the presence of three factors, specifically there was a tactical reason for the failure to, or for asking for the erroneous instruction, that there was that the experienced defense counsel who was heavily involved in the charge conference, and that the error in the jury instruction had been well established or well known. And I think all those factors are present here as well. There's a tactical reason for using the independent instruction in a case involving felony murder and an underlying felony, because you can kind of interject this type of error into the case. This case involves experienced defense counsel. She was involved in the charge conference. This isn't a case where the judge just asked, do you have any objections to the jury instructions? And counsel's like, no objection. She's involved, she's making changes during the charge conference. And furthermore, the problem of the independent jury instruction in cases involving interlocking charges is well known, so well known in fact that we've created our own, a different jury instruction for these cases. So I think given all those factors that were present in the night, I would say that you cannot bring this error was either invited or waived.
One of the contentions in your brief, as I recall, is that you can't challenge a true inconsistent verdict with a motion for arrest of judgment, but then you also say you can't challenge it under a 3.800B. So how does one challenge, if this was a true inconsistent verdict, how would it have been the appropriate way to challenge it?
I'm not sure off the top of my head what
Because in Morris, in our recent case on a true inconsistent verdict, also out of the Eighth Circuit, we allowed a motion for arrested judgment to preserve a claim of true inconsistent verdict. Were we wrong in Morris to do that?
I think it does not fit within any of the specifically enumerated categories for an arrested judgment. There's 4 specifically enumerated categories, and I don't think such a motion fits well in. But I also think it's pretty clearly not a sentencing error. There's a lot of case law in the inconsistent verdicts area where I think it's appellant cites Zelaya and Proctor out of the 2nd and the 4th district. Those courts find that a true inconsistent verdict is fundamental error, which of course is an implicit finding that it's not if it were a sentencing error, it can't be fundamental error because you have to actually preserve a sentencing error via either a motion in the trial court or a 3.100B2 motion. So I do not think you can preserve this via 3.100B2. I'm not sure what specific motion a trial attorney should use to preserve it in the trial court. But going back to the merits, basically, I think a true inconsistent verdicts issue is a factually inadequate theory. The problem in this case arises from the fact that the jury did not find that a robbery occurred. And I'd cite from the initial brief, which states that the problem in this case is for the felony murder to have been legally adequate, the state would have had to prove the killing occurred during the commission of the robbery. So I think even this appellant agrees that the problem is the lack of a fact. And that is not that is a factually inadequate theory, which is not a problem. As the Supreme Court noted in Griffin, the problem with the reason we reverse in a general verdict based on a legally inadequate theory is because jurors aren't competent to assess legal inadequacy. There's the 3 categories, which are a theory that violates the Constitution, theory that's procedurally barred, or a theory that involves conduct that's not criminal. Your average juror is not going to be able to assess that. Your average juror isn't going to know that the crime was outside the statute of limitations. However, your average juror is in fact well equipped to determine whether the evidence supports a theory, whether there is in fact evidence of, in this case, a robbery. So the jurors finding that there was no robbery makes the felony murder based on robbery theory factually inadequate, but it's not legally inadequate. And factually inadequate theories are fine. That goes all the way back to common law. Turning to the second issue, I would just point out that even if the fundamental error standard for IAC on the face of the record is an extremely high bar, and I think this court has explained it, that the fundamental error in this context only occurs when counsel's alleged failure to object or otherwise act was so egregious that the trial court should have intervened even without prompting by an objection. And I don't think the failure to mention a second DCA case the failure to mention that second DCA case was so egregious that the trial court should have done it itself. Even if he would have done it, I don't think he can show any prejudice, because even if he can sidestep the erroneous legal reasoning in Shavers by saying the trial court was bound by it, Shavers still says you do a fundamental harmless error analysis. And as I've stated before, I think the harmless error analysis in this case comes out in the state's favor.
As far as the ineffective assistance claim, would you at least agree that there's no conceivable strategic reason why there wasn't some motion, whatever the appropriate motion is, to point out the potential of an inconsistent verdict?
If I believe the claim had merit, I would agree that there is no strategic reason. But I think there's no merit to this claim. I don't think that this claim had any chance of succeeding, so I think counsel can't be ineffective for failing to raise a meritless motion. And if there are no further questions, the state asks that you please affirm.
Counsel.
Thank you. I'd like to just try to make a few points. First of all, I just think it's critical to distinguish these arguments as they relate to issue 1 versus issue 2. I do think, some of them are kind of getting crossed up, and I agree that some things may overlap, but I do think that's very important. Just for instance, I don't think a harmless error analysis would apply in connection with issue 2. I mean, there the argument is clear that it's fundamental error, and we all know that a fundamental error can't be harmless. The other big point I'd want to kind of make along those lines is I don't believe a trial judge would have been required under Shavers to make a harmless error analysis. I mean, a trial judge doesn't have discretion to say, well, I know this is the law, but I think it's harmless anyway. That would be an abuse of discretion. So, of course, appellate courts conduct a harmless error analysis, but I don't think a trial judge can get away with doing something erroneous by thinking, well, it's harmless. So, And I would just emphasize that even if Shavers was not directly on point, again, on the merits, where Shavers is concerned, I think it's important to distinguish the merits from the harm analysis in Shavers. Fitzpatrick, I believe, would be very persuasive here in a motion for arrest of judgment. Certainly the lawyer should have cited Fitzpatrick as well. I would also say that in terms of kind of just the interrogatory, for whatever it's worth, the interrogatory, yes, could have been consistent with premeditated murder, but it also could have been consistent. I mean, firing a gun would have been consistent with a killing during the course of a felony, including theft under legally inadequate theory. Even if the error was invited in connection with the legally interlocking instruction, which for the reasons in the reply brief, I do not believe is the case. It was just mere acquiescence. There was no discussion in depth at all. If you look at page 1164 through 65 of the record, that's the most relevant portion of the charge conference, and there's just no discussion about a legally interlocking instruction. But even if that was invited error, it would still be ineffective assistance of counsel, in my view, and fundamental error to not then file a motion for arrest of judgment down the road. I do think those two issues are distinct. I'd also emphasize that for the reasons discussed in the reply brief, Ford should not prevent this court from reaching the conclusion I'm asking for here. And just to conclude, I would say this is the rare case where, again, a district court decision as to which there's no interdistrict conflict is directly on point. At a minimum, there are other binding case decisions that are on point. This is also the rare case where a trial lawyer at any 3850 hearing would not be able to offer some strategic or tactical reason for their failure. Finally, this is the rare case where the trial judge should have at least just spoken up. And so in those circumstances, I think this court could fashion an opinion in Mr. Proffitt's favor that's limited to these unique facts. And that's what we'd ask this court to do, to reverse and remand for a new trial. Thank you.
Thank you. Thank you to both counsel for your arguments today. The court is now adjourned.
All rise.